Supreme Court has extraordinary power under Article 142 to give an order to render complete justice in a case before it. There are so many cases which are stuck for want of a procedural fairness and flexibility. So much of injustice is meted out if the Supreme Court does not intervene and speed up the justice. So where there is a procedural rigidity, for example, under the Hindu Marriage Act, if a couple is not getting along, they have to mandatorily wait for 6 months so that they can celebrate a divorce. But the Supreme Court can step in and say, why 6 months when there is no possibility of retrieval of marital happiness? And therefore, under 142, it can step in and say, this marriage is dissolved and liberate the couple, individually, of course. They are in a limbo otherwise. So the Supreme Court under Article 142 enjoys extraordinary power where there is procedural rigidity and where there is institutional inertia and the institution doesn't function with the speed and efficiency it is expected to because intimate matters of justice are involved. I will give you a lot of examples here, and by the strength of the examples, you will be able to know when the Honorable Apex Court can intervene and when it does not. Let's go back to 1985. There was an old lady called Shah Bano. She was divorced and the husband was refusing to take care of her beyond the iddat period. She goes to the Supreme Court seeking justice. Supreme Court says the Criminal Procedure Code, Section 125, applies to all destitutes and personal laws are not respected. And only the CRPC is respected. That is how the old lady gets maintenance for the rest of her life. That was in 1985. Which means that a law has been made applicable to the helpless people. This is justice for women and justice for the helpless. So that is liberal interpretation of the law, setting aside a personal law that does injustice to women. That is Shah Bano case, 1985. And 89, about $500 million worth of compensation was ordered to be given by Union Carbide, whose Bhopal gas factory blew up, killing thousands of people and injuring forever, and next generation also many thousands and lakhs of people. There's no law here. If there was a law, each individual has to go to the court seeking compensation and waiting for it for decades together for justice. Justice may not come also. So the Supreme Court activated Article 142 and said that about $470 million have to be given as compensation for all the people who've been negatively impacted, adversely impacted by the Bhopal gas disaster. That was a classical 142. Now you come to the recent Ayodhya Rama Janmabhoomi. The land was given to the temple. But the Supreme Court thought that since they said that the Muslims also have a case, but the law doesn't allow Muslims to get any land here because all the land has gone to the temple, the Supreme Court under Article 142 created a separate provision whereby 5 acres of land was given to the mosque appellants. That was justice under Article 142. Then you come to, there was a person, little kid, he cleared G Advanced and he was to get into IIT Dhanbad. And 17,500 rupees had to be paid by a certain date. He could not arrange. The IIT cancelled his admission and he goes to the Supreme Court. Supreme Court says this is unfair and relaxes the timeline for him to pay the fee, and that is how Atul Kumar's entry into IIT Dhanbad had been facilitated by Supreme Court pressing the 142 button. Then I will take you to the famous Perarivalan case. Perarivalan assassinated Rajiv Gandhi. That was in 1991. And he was given death sentence, and because of the inordinate delay by the Shatrughan Chauhan case, the death sentence had been commuted to life imprisonment. He already served more than 14 years. So he appealed for remission. The Honorable Governor was sitting on it, and the Supreme Court said that the inertia of the institution of the Governor is meting out injustice to Perarivalan. And the Honorable Supreme Court in Perarivalan case in 2022 released Perarivalan on behalf of the Governor because the Governor was sitting on the file and not acting. That was Perarivalan. And think of the sex workers being harassed by the police. In the case in 2002, where in the Karmaskar case, the Supreme Court said sex workers should not be harassed. They are there by consent. If they are there by consent, they should be treated with dignity. Their children also should be taken care of. That is the Budhadev Karmaskar case 2022. Again, Article 142, because there is no law to take care of sex workers in the country, to give them a feeling of dignity, treat them with a sense of dignity and taking care of their workers. There is vacuum. So you remember, Article 142, we already have discussed the fact that where there is regulatory rigidity, the Supreme Court steps in under 142. Where there is no law, the legislative vacuum is filled up by the Supreme Court. And where the institutional inertia is seen, the Supreme Court steps in, as we have seen in the case of Perarivalan. Now let us see another case, the Falodi case. You know, 2% of the road network in the country, which is the national highways, sees 30% of the road accidents. Supreme Court took cognizance of it suo motu. The Falodi in Rajasthan, where the national highway saw a road accident, the fatalities, Supreme Court said that right to safe travel is a part of Article 21, right to life and personal liberty. A new right has been created within Article 21, adding to the existing family of rights that have been derived from Article 21, because the scope of right to life and personal liberty is expansive. So a new right has been created, and the Honorable Supreme Court has given directives to the state governments and the center how to take care of the road safety. For example, the emergency disaster response force and how they should act, etc. The parking rules and dhaba rules, all that. So Falodi, Atul Kumar, Ayodhya, Perarivalan, Budhadev, Karmaskar, Bhopal gas tragedy, and Shah, Bano. All these cases show you under what circumstances the Supreme Court can press the 142 button and get into action so that justice is meted out. For a number of reasons we have seen. Inertia of the institution, or regulatory or legislative vacuum or gap, and of course, adding to the existing rules for more justice. That is Article 142. So you can create a new right here. You can write a law where there is a vacuum. You can push an institution that is sitting on files and not acting. And you can also give instant justice where the procedures are too rigid. Hindu Marriage Act. So that's Article 142. But then that should not lead to judicial legislation. That should not lead to judicial overreach. Where it does, there will be public outcry and the Supreme Court will recall its own verdict. Therefore, there are checks and balances. At times, these balances become imbalances, and instantly or within no time, they get restored to the constitutional balance. That's about Article 142. You will get everything about Article 142 here. Go through, feel comfortable.